The petitioner is the one that has what we call the burden of proof. It's your job to convince the judge to do what you want them to do. It's not the judge's responsibility to figure out what needs to be done. And I see so often when parents go into court, they're not really sure what they want the judge to do, and the judge isn't even sure what they want
the judge to do.
And so it's very important that you understand it's not the judge's responsibility to figure out what you want and then do it. It's your job. And you have to prove that your child or your loved one needs a guardian with what is called clear and convincing evidence. And we've had a great case study on beyond a reasonable doubt. I think the Casey Anthony trial, that jury did not feel that the case was proven beyond a reasonable doubt. That is not as far as we have to go. What we have to do is clear and convincing evidence, which means, the way I like to put it is, anybody has to look at what you're going to show and say, yeah, that person needs a guardian. You know, it's that clear. I do know that many of the judges will spend a little bit of time trying to develop, you know, if they don't feel they've reached that point yet, they might ask some additional questions to try to see, you know, which way it's going to gel. Is it going to gel that yes, they need it, or no? I don't know if you want to address some of that. This might be getting into...
Generally, it needs to be that a reasonable person would see pretty clearly that this person needs help, that they are unable to take care of themselves or their property. And I let everybody present their evidence. And if they fail to meet that standard, then they lose. But you have to be prepared for a judge who isn't always so patient because they've got 15 other cases to hear that day, and you've got to get your point across pretty clearly and pretty efficiently, because there are times where if you've been talking for half an hour and you haven't gotten to the point yet, the judge is going to be like, clearly you don't have anything that's going to convince me, so I'm going to move along.
And if we could save questions for later. One thing, as parents of special needs individuals, we always want to look at the positive sides. We always want to focus on what they can do. The 15 minutes you're in court, you got to focus on the things they can't do, because the judge cannot rule based on what they can do. The judge has to rule on what they're not able to do. So for that 15 minutes you're in court, that's what you focus in on. Once the hearing's done, you never have to go back there again. So I see too frequently, in fact, when I'm sitting with a family and asking about their child, and they're telling me about all these great things that they're able to do, I'm thinking, you know, there's not going to be enough evidence here to support the need for a guardianship. And they're like, oh, no, they need a guardian. I'm like, well, you're not telling me why they need a guardian. And so, you know, it really takes a little bit of time to get to that point. You know, and then I find out that they're reading on a second grade level. You know, at school on their IEP, they have an IEP goal of, you know, true-false questions, getting them right 50% of the time. And I got to tell you, when I see that IEP goal, I laugh. A completely random selection you should get to 50% at a time on a question that gives you just two options. So this child was actually performing less than that, so there was clearly something wrong. But for the 15 minutes you're in court, you got to focus in on what your child cannot do, because that's the only information Judge Wolk or whichever judge you're in front of has about your child.
You're on vacation for a week and someone's taking care of your kid. What do they need to know that you do for your child every day? If you bathe your child, if you dress your child, if you feed your child, if you prepare meals and they feed themselves, if they can make a sandwich but they can't cook on the stove, if they can make their own doctor's appointments, get in a car and drive themselves to the doctor, drive themselves home, get the prescription, drive themselves to the pharmacy, fill that prescription, and then take the medication appropriately, go ahead and let me know that. If any of those things are untrue, those are the things that a guardianship is meant to address. Look at what a caregiver would have to do if they were taking your place. That gives the judge some insight into what you're talking about when you say can't. This is in no way a judgment on your parenting skills. This is no way a judgment on the accomplishments that your child has made in spite of the decisions that God made about how they should be formed. This is in no way anything like that. This is, why do we need to remove these rights and transfer them to you? So, as Mark says, it's a really difficult thing to sit in an open court with a lady sitting right next to you, taking down every word you say, and talk about your child's weaknesses when that's not what you want to focus on. But it is important.
And in many cases, one of the most simple ways to demonstrate the need, bring your child to court with you. You don't have to. But if your goal is to present clear and convincing evidence, if Judge Wolk meets your child, now, if it's medically not advisable to do that, don't do that. You know?
And if it's going to make it really, really hard for you to tell me what's going on because you don't want to say what your child can't do, and you're more comfortable, and the court-appointed attorney is willing, this is an important thing, if the court-appointed attorney is willing to waive your child's presence, because they have a right to be there and hear everything that's said, but if they're willing to waive that and say that they're not able to appropriately, or now I'm drawing a blank, to advance the hearing, then they're entitled to be there. But if they can't do that, then they can waive their presence. In most counties, there are some judges who will not let you waive a proposed ward's presence. I know of judges who have gone and conducted hearings in the waiting room of an ICU unit because they will not waive the ward's presence. This is a person who is clearly in the ICU. She's there. She's conducting the hearing, seeing them through the glass, but they insist. So most places it can be waived, but not all.